Good. Well, welcome everybody. I'm Kristen Boon. I'm a law professor here at Seton Hall Law School, and it's a great pleasure to welcome you all here today to discuss the topic of UN accountability. I'm really thrilled with the quality of people that we have in the room today. This is really is an experts panel. I'm particularly grateful to Philip Alston, who'll be giving our keynote address today, for making time in his extremely busy schedule to come and really head off the discussion. So our accountability is a multidimensional concept. It's legal, it's political, it's administrative, it's financial, and we are going to be broaching all of those different dimensions today. But of course our focus is going to be mainly on the legal. And this topic is really evergreen. I remember when I was a law student talking about UN accountability, and so it goes back some time, but it is still pertinent. And there are, of course, a number of recent cases that have been brought regarding UN activities that demonstrate its continuing pertinence. I speak, of course, about the case brought against the UN establishing that Nepali peacekeepers introduced cholera into Haiti, and also evidence that a Roma population was resettled to a lead-contaminated site in Kosovo during a UN territorial administration. And there are other examples, too. And I think there was a widely shared feeling amongst many people, many strong UN supporters, that the UN's response was inadequate, but also that some member states were not stepping up to rechart the course and to push a better outcome as well. So the UN is an organization of member states, and we are talking about UN accountability today, but I don't want that to overshadow state responsibility or the responsibility of other international organizations as well. Now, there's 4 themes for discussion today. We're going to start off talking about the strengths and weaknesses of external accountability. We'll then talk about the concept of responsibility in international law, models of internal dispute resolution, and finally, standards of compensation. Notably absent from this list is the topic of immunity, immunity of international organizations. And yet it's also the necessary starting point. And so I just wanted to spend a couple of minutes sketching out some ideas about UN immunity. Now, the reality is that there are very limited venues through which individuals can bring claims against the United Nations. This is due to the UN's immunity from national courts. And although the UN Charter describes functional immunity, in reality the UN's immunity is absolute. We might think of this as the UN's external immunity. However, the UN does have an obligation to provide appropriate modes of dispute resolution for private law claims. However, the line between public and private is not settled. And in fact, the response to some of the claims that have recently been brought against the UN is to expand the definition of public law claims. As a result, the UN is correspondingly asserting broader immunities. And the net result of that is that the UN is asserting it has broader immunities altogether. And this is in contrast to all other fields of immunity. State immunity, diplomatic immunity, the immunity of charitable organizations, of federal governments are shrinking. And so in some sense, this is quite an anomaly. Now, I want to be clear that the UN responsibly settles many private claims, including contract disputes, employment disputes, small torts, and so forth. There is a significant lacuna with regards to human rights and overlapping torts claims. And so the result is what has been called a denial of justice problem. And because the UN's immunities are really severing the right to a process and to a remedy. And so we find ourselves at a point where we need to ask, do we have a problem with first principles, or do we have a problem with implementation? Now, I'm suggesting the first issue is settled, and I have gone on record as saying that I don't think that the UN has absolute immunity, that I think that the better reading is functional immunity. The program today is designed to focus on the second question, implementation of UN immunities. And so we are going to be thinking about whether the common remedies to the immunities problem, national dispute resolution, waiver of immunities, are adequate. We're going to be thinking about what models we should be drawing from in terms of next steps. Now, there will be a rich discussion today, so all I want to do is pose some questions at the beginning, and I look forward to a conversation with everyone afterwards. Now, let me start with one observation from the ILA report on accountability, the Berlin report from 2004, which I think remains very pertinent to these discussions. The ILA group noted that there were 3 different levels of UN responsibility. There was responsibility for internal administrative matters, for a second level of tortious acts, and finally for responsibility for the breach of international obligations. currently, the regime is really focused only on that third level, responsibility of breaches for international acts. And so I hope one of the things that we'll do today is talk about responsibility for torts and how, as lawyers, we need to think that through. In addition, our current concepts of responsibility are limited. The articles on the responsibility of international organizations give almost no place for individual claims against organizations, and they really don't elaborate on shared responsibility. And so how we share responsibility between organizations and member states is, I think, a critical issue. Finally, the border between public and private law claims is in flux. Who should decide that? Should it be the International Court of Justice? Can we anchor these definitions to other principles of law? I think these are interesting questions for our first panel. With regards to dispute resolution, what design features are important, right? We have to have something that works politically, but also that works legally. And so I'll be very interested in hearing what the panelists think about whether we should have an adversarial system or a conciliatory system, whether it should be judicial or non-judicial, whether dispute resolution mechanisms should issue binding or non-binding decisions. And here I think it's helpful to think of models that we have not only within the United Nations, but within other international financial institutions or organizations as well. Related to this, I think there's a question of whether national courts should have an oversight role of dispute resolution mechanisms within international organizations. How can they effectively assess the nature, the existence, and the sufficiency of what happens within international organizations? And our final panel will discuss compensation. Now, when an international organization is responsible, what standards of compensation should apply? Should we be limited to the kinds of principles that are laid out in the articles of the responsibility of international organizations? Are those the right ones? The concepts of compensation, satisfaction, cessation, non-repetition. Should we have a more victim-centered approach? Right? Or are there other ways that we should be thinking about compensation? The practice of ex gratia payments or charitable contributions have been criticized, and I think this will be an interesting opportunity to discuss what the right models are for tortious acts. In particular, should compensation be individualized, or should it be lump sum, paid to states, kind of a public law angle? So the order of business today is that we'll start with our keynote speech by Professor Alston. Following that, we'll have a 15-minute Q&A. We'll then move to our first panel where we'll discuss responsibility. We'll have a short coffee break. We'll reconvene and have two other panels that address dispute resolution and compensation. And then we will wrap up with a wine and cheese and a book launch of Larissa van den Heerik's new book on in international law. I just wanted you to know that today's event is being recorded. We may rebroadcast some of this afterwards on YouTube. If you would like your remarks to be audible, it's very important that you speak into the microphone. If you would rather not have your remarks out there, then we will deal with that afterwards. But I just wanted you to know that the microphones are on. And I would also just like to acknowledge the help of my assistant, Paula, who is out there right now. Paula has been working tirelessly in her third trimester of pregnancy, which I greatly appreciate. Many of the panelists have communicated with her. So if you have a chance, just thank her when you're around. I'd appreciate this because she's put a lot of effort into making this a successful event today. So let me now turn the floor over to Philip Alston. Professor Alston is at NYU Law School. He is, of course, the UN Human Rights Special Rapporteur on extreme poverty and human rights, and he wrote an extremely important, a game-changing report, really, on the Haiti cholera situation last year. He has degrees from the University of Melbourne and from Berkeley Law School. He's a renowned scholar in many fields of international law, including civil and political rights, economic and social rights, and public international law. He's a busy guy, and I can't thank him enough for having made time to come here today and to share his thoughts on a topic that I know all of us have really been watching very carefully. It's close to our heart for the last couple of years. So I'll turn the floor over to you. Thank you very much.
Thanks, Kristen. That's a hard act to follow in terms of a rapid-fire list of major challenges. Let me say that I'm delighted to be here and very happy to talk about these issues. Before doing that, I should single out and thank Christian van Veen, who is in the back of the room, who works with me on everything I do as Special Rapporteur, and certainly on this, as in all other issues, is absolutely central to the work, and should accept at least half of the blame for most of the things that go wrong. So the focus is on accountability mechanisms and how they work. And what I want to do is to just reflect on the Haiti exercise, not going into any background detail. I'm going to assume that most of you have the requisite knowledge. Some of you, as I've said, have much more than I do. Cholera, as we know, happened in October 2010. That's the way it was described. It just occurred. It appeared out of somewhere. The question then is, what were the internal accountability mechanisms before we get to external that the UN might have had in place? Here, I'm not going to dwell on the fact because there are other panels, but it seems clear that in any peacekeeping type context, a whole range of factors generally conspire to inhibit and limit on-the-spot accountability. I had the dubious honour of being on a Security Council Commission of Inquiry into problems, to use the euphemism, in the Central African Republic a couple of years ago. And in that context, a lot of the sexual abuse issues arose, although we were looking specifically at crimes committed by various sides to the conflict. But I became singularly unimpressed with the mechanisms that were available on the spot for achieving any sort of accountability. Actually, I shouldn't say unimpressed, I should say deeply depressed. But I won't pursue that issue because we'll return to it. But ideally, one would like to think that there would be built into some of these missions a capacity to be able to react in an accountable way fairly early on, rather than letting operational demands overwhelm everything. We then have the role of the Secretariat. In other words, what did it do when the problem arose and when the allegations were made as to the origins of cholera? Initially, as I said in my report, the Secretary General acted admirably by appointing a commission of independent experts. And that was pretty good. It was appointed within 3 months of the outbreak. I suppose, in principle, this is good. It reported 3 or 4 months later, so it moved quickly. But what we see if we examine the report is a pretty low quality of analysis, not very good science, and the completely inappropriate use of legal terminology in order to arrive at a conclusion which conveniently exculpated the UN in particular. It has all of the hallmarks of a negotiated compromise, and also one which was infected by dubious legal inputs. I won't try to suggest where those inputs might have come from, but somebody had an interest in slipping into the report a formulation which exonerated the UN and rendered the report pretty useless. That then is a great pity. It causes us, it goes well beyond this conference, to reflect on how inquiries of that sort by independent experts should be structured, how one can hope to guarantee, if one ever can, a more objective outcome. Because while the principle was excellent, the practice was pretty awful. You've then got the legal advisors of the UN, which one might have hoped would be the next level of internal accountability. But here, what we've got is a pretty sad story, I think. I have gone on record as expressing my views on this, so I won't be coy all of a sudden now. You've got a process which was really dismal, this simple dismissal on the basis of a couple of sentences in a letter, or two consecutive letters signed by the legal counsel, of what seemed to be justified claims, and more importantly, of pleas for further discussions. And the legal counsel simply said there's no basis for any discussion here. I've decided, even though my decision appears to be completely counterintuitive to most external observers, there will be no discussion. Please go away. That's an extraordinary process in terms of any form of accountability. You've then got, and we can come back to that, but I find it really a major element, is the lack of any requirement on OLA to provide a reasoned justification. We talked a lot in this process about the legal advice or the legal opinion. I'm fairly confident now that there probably never was anything that would decently resemble a legal opinion. It was a sort of defensive move, the inclusion of a few sentences in order to get rid of the issue. And that, I think, is why nothing has ever emerged. But that's a very bizarre basis for serious decision-making within the UN Secretariat. No reasoned analysis provided at any stage to anyone. And linked to that, of course, is the complete lack of transparency. I talked to senior UN officials at the highest levels to try to get hold of any indication of what the reasoning was, and nothing was ever forthcoming. Now, that's a very bad recipe for any form of internal accountability. So we move then to external accountability. Not a shock. There are many institutions that will never hold themselves accountable, and that's why we have external actors who are supposed to kick in. Maybe it's how it should be in a way. It's certainly how it almost always is at a certain point. First of all, states should be, I think, the key actors in terms of exacting external accountability from the UN when it has screwed up and is not prepared to acknowledge that. Here there was a curious combination of factors leading to almost complete inaction, from what I could see, across the board on the part of states, and that's pretty shocking. I could reflect on the potential role of racism. I don't really want to go down that road, although I think you know what I'm getting at. Who cares about a small, irrelevant black population in the middle of nowhere? Who's going to stand up for them? What's the point? They're losers anyway. I think that sort of mentality was probably quite instrumental. Non-governmental organisations, to whom we always look, of course, played an absolutely vital role in all of this. If it hadn't been for the NGOs putting the issue on the agenda and hammering away endlessly, the issue would have pretty much died away. The medical profession is interesting, but it's not one that I'll go into here. Anyone who's familiar with the work of Dr. Renaud Piarou, the French epidemiologist who behaved pretty much heroically, I would say, in all of this. But that contrasts with the American medical establishment, with the Center for Disease Control and others, who seemed, according to the excellent book by Ralph Frerich, to do everything they possibly could to bury this. And so the medical profession certainly doesn't emerge with any great credit from this exercise, although they should be involved in some way in accountability. The legal avenue, I think we can take some pleasure from the fact that even an almost guaranteed loser of a strategy, in other words, suing the UN in US courts, nonetheless had a pretty dramatic impact, both negative and positive, in the sense of providing a justification for the American government and for UN officials to say, oh, we can't do anything now because we're being sued and there's a risk and therefore this is all on hold. But they wouldn't have done anything anyway, and at least the litigation forced them to think more carefully about what the issues were. Finally, and of course I risk becoming self-centered here, but that's what I'm here for in some ways, the role of the UN Special Procedures, the group of experts linked to the Human Rights Council. And I want to talk about that for 5 minutes just to try to put that into context, because I think it is important. One of the questions that was legitimately asked to me, including by a US ambassador, was, excuse me, what are you doing involved in this? The rapporteur on extreme poverty is not exactly at the forefront of UN immunity issues. The answer to that was maybe convoluted, but fairly simple, which was that there initially were 4 rapporteurs, all of whom were thoroughly involved: the expert on Haiti, the expert on water, on health, and who have I missed out? Housing, was it? Anyway, yes. They all had very direct involvement, and at a certain point when things weren't going anywhere and when the Special Rapporteur on water and sanitation had changed, I became involved in the exercise and ended up, really mainly because I was based in New York and they were not, and I was able to pursue the strategy that I'll describe in a moment, taking the lead. But otherwise there was no particular rationale for me being the key person here. So I would like to see, and I think many people do, that the role of a UN Special Rapporteur is about accountability, holding states and other actors to account in a whole different range of ways and contexts. And so it's not surprising or inappropriate that they then ended up trying to play that role in relation to this particular issue. I want to then just go back to one dramatic moment. I had been in negotiations with the UN, as I'll describe, for a rather long time. I had provided a deadline, which was that if I hadn't heard anything from them by the 19th of August last year, we would go public, etc. Christian van Deen and I were in Beijing on a mission. We were in the back of a van, traveling large distances in heavy traffic, carefully engineered by the Chinese government to make sure that that took up much of the time of the mission. And at a certain point, someone said, so have we heard from the UN? I looked at my iPhone, and there a friend had sent me a note saying, Philip, you might be interested in the story in the New York Times this morning, which was the first time that I had got any specific response from the UN. And it announced that the UN, after having thought about this for almost a year, had now decided to adopt a whole new strategy. So the coincidence, of course, was not coincidental, that the deadline was the 19th of August and the UN announced this dramatic new strategy on the 18th of August, publicized in the Times the next day. But what's important, I think, is to very briefly note the background. When the Special Rapporteurs first wrote to the UN, they got a very limited response in November 2014. We took the decision then that we shouldn't just leave it at that, that we should follow up, which is somewhat unusual because rapporteurs are normally supposed to stand up and object and then go home. But rather than saying we don't accept your explanation and we demand what we demanded initially, we instead suggested that there might be informal consultations held, which was an interesting strategy. But it was a presumptuous one in a sense. You know, who the hell are you to suggest that informal consultation should take place, and why the hell would we talk to you anyway? But eventually it worked. First of all, that was in October 2015. What we got was reports from inside the Secretariat that nothing was going to happen, that there was great pushback, that the matter had been decided much earlier, and that was it. I was given strong informal advice from Geneva that this was not an issue that should be pursued, that it was a lost cause, and that it was politically too hot to handle, and they didn't want me to pursue it either. I then asked for a meeting with the UN Secretary General, and I got it, surprisingly, in January of last year. It was a meeting just of a handful of us, and one of the two issues I raised was the Haiti issue. The Secretary General, I think I can say, shocked me in a sense, because he immediately went into this discourse about, well, Mr. Alston, you know, we don't really know what caused cholera in Haiti, do we? And I sat there thinking to myself, no, surely, have you swallowed the internal propaganda? I mean, is that really what you think? And it was clear that it was what he thought, that, you know, this is very contested. I mean, what can I do? And so I made a pretty strong plea that I thought this was a very significant issue for the UN. I mentioned the Secretary General's legacy, which was the principal thing on his mind at that stage, with less than a year to go, and suggested that this would be a rather important issue to try to resolve. 6 weeks later, 5 weeks later, a letter came from the Deputy Secretary General, which had two prongs. One is, well, yeah, we can discuss. And the second was, but of course there can't be any change in our policy. But that was fine. It provided an opening, and it came from the top, and it reflected pretty furious, as I understand, internal discussions about whether we reopen this issue, whether we engage with these busybodies, basically, or not. But the decision was there. It came from near the top, and it was significant. I then had discussions with several officials, informal, and I indicated that I thought the most important thing might be to then have some sort of follow-up meeting. Eventually, the offer was made to organise a non-meeting. You know what a non-meeting is. It's like a non-paper. And the non-meeting then took place on the 15th of April. Christian was there as well. And in that context, I basically made what I thought was a sales pitch, which started off by saying, look, of course, you know that there is UN responsibility here. That's not really contestable, in my view at least. But the challenge is how we get out of this as the UN. And now I'm talking about us, in a sense, because I think it's really important for all of us to find a way out. And I think there are easy ways out, believe it or not, which would be in everyone's interests. So at the end of that, there was lots of, okay, well, let us think about it. The one outfit that I won't go into any details, other than to say the one outfit that really didn't engage at all was OLA, that just sat there and listened. But other more substantive parts were clearly worried, because the advice that I'd got informally was that there were a lot of staff members who felt that this was a shame, it was a terrible precedent, and that it was something that could have been resolved if the will had been there. After that meeting, there were lots of discussions, again informal, about what I could be given to make me happy. And at one point, and this hasn't been stated publicly, but I think the time has come to it's not particularly exciting, but not to conceal any of the steps, it was suggested that the UN would actually draw up an inventory of all that had been done. My initial reaction was that I thought that was a complete waste of time, that I could have drawn up the inventory myself and it wouldn't have taken too long. But I acquiesced in the end, saying, well, it's always a good thing for a bureaucracy to have an ongoing focus to keep the issue alive. And so I understand that work was done on the inventory. I then heard nothing, and so I talked to my fellow rapporteurs, and we decided that the best way forward was for me to use the report that I was entitled to present to the General Assembly last year as the vehicle. They didn't have a report that they wanted to devote to it, and I was happy to do it. So I then went back to the UN and said, look, I don't want to write a report on this issue, but I will have to start writing something by the middle of June in order to do it. If there has been a breakthrough, if the Secretary comes up with a response by the middle of June, I'm very happy to write on something completely different. I'm an academic. I can churn out bad papers very quickly. Nothing happened. And so we set in motion the process of writing the report. Then the New York Times broke the story that there would be a whole new strategy, entirely new strategy, I think was the term, that the UN would adopt. They talked in very positive terms about things like consultation, participation, and so on. They even talked about transparency. The statement and remedies for individuals. The statement seemed like a superb breakthrough. Seemed like a champagne moment, I think, to many of us. I was in Beijing still, but a couple of days after I got back, I was invited to a private meeting with the Secretary General and the Deputy Secretary General, just the three of us. Rather unusual not to have staff members in there and following and trying to manipulate everything. It was a very revealing meeting. It indicated that the principal obstacle to all of the things that I was advocating was coming from OLA. There were indications from both of those two senior officials that they didn't think that this obstacle could per se be overcome. I followed up with a number of exchanges with the Deputy Secretary General, both oral and in writing, but all confidential and informal, but trying to see if we could push for some sort of resolution. So that's the story, in a sense, in terms of trying of exacting accountability from the outside. And I think it did achieve a very significant breakthrough. Let me go on. I've only got a few minutes left, so I better be quick. The question then arises, so who's going to take the lead in the next phase? It's been put back on the table. It's opened up. There's a new strategy being drafted. The special rapporteurs, it's an interesting thing which I've seen particularly on commissions of inquiry, that once a commission of inquiry has been completed, the chair suddenly has no status whatsoever, is not really able to speak. I mean, on whose behalf are you speaking, sir? And the answer is, of a group that I used to chair and I used to have a mandate, but you're finished. Special rapporteur, not quite so straightforward, but I didn't have any obvious role. The Secretary General had asked me if he could appoint me to an internal advisory group, and I said, whether rightly or wrongly, no. That's not my role. I need to retain my independence. I can't be compromised by being an internal advisor. Wouldn't be good for you, wouldn't be good for me. And so I was more or less out of it. There's a funny little story that can be told in this context. I haven't spoken about these issues at all since they happened, but first of all, on the day of my presentation to the third committee, which is about a year ago, suddenly I was told, just as I was about to take the floor, that the video streaming wasn't working mysteriously in the third committee. It was working for all of the other committees, but something had happened just that moment. I scheduled a press conference for immediately afterwards, and for some reason, when the list of press conferences was sent around, all of the others were listed, but mine wasn't listed. Don't know how that happens. Terrible mistake. And then the next day, when I went back to the UN, I discovered that my access pass had been cancelled. So these were sort of funny little incidents in terms of demonstrating how gratefully received my efforts had been by the Secretariat. So actors who should then have followed up. One of the big, the elephant not in the room, of course, is the concerned state, the government of Haiti. I won't speculate on that here. There are lots of interesting reasons why they may have been absent, but it creates a huge problem because we sort of put so much stake in a state being able to assert its own rights, and if it sits meekly for bad reasons, then you've then got other member states, and here there was a remarkable lack of political will, as I had indicated earlier, but there was also an absolute determination on the part of certain key states that nothing would happen with this. And clearly they were working very closely with the office of, with OLA. Let me go, I was going to say more, but I should wrap up. So let me finish then with a couple of observations about some ingredients for accountability, both specific to this case, but also more generally. The first point is a pretty simple one, and that is that as international lawyers, we normally look for institutions and procedures. We've got to set up a new institution that's going to be accountable. We need Kim Prost to suddenly be given a larger mandate and more powers or whatever. But the reality, and you know, that would have been great. The reality is that culture and mentality are actually the key to all of this. So if you have a culture which is not accountable and which just instinctively closes down, doesn't matter how many institutions and procedures you set up, won't make any difference. That then leads, of course, to the principle of top-down leadership. It makes a huge difference what message is sent from the top and how it's sent. And the message on Haiti was very, very, very clear. Whatever the two top officials might have told me, they were not prepared to tackle the key issue underlying all of this. Transparency is extremely important. Transparency both in terms of information and of procedures. That's an issue that I would like to pursue more of in the UN context. I still find it absolutely shocking that OLA doesn't have to publish or make available, even redacted if necessarily, when there are, you know, top secret issues or whatever, legal opinions on issues of the utmost importance. And so the lack of transparency then encourages this notion that in fact OLA is really there as a political, legal fixer trying to smooth things behind the scenes rather than playing the role of a genuine legal advisor. And I'm not being romantic here. I'm not suggesting that lawyers go in and always tell the truth, etc. But lawyers should have certain constraints within which they operate. Unfortunately, Secretary General, this is what the law says. But of course, it's open to you to do X, Y, and Z. But I think only something like transparency is ever going to lead to that issue. I remember vividly having confronted the UN very strongly over accountability for complicity by peacekeepers with forces that were committing crimes and human rights violations in the DRC. And I made a big public fuss of the issue, and within a couple of days the Deputy Secretary General announced that they were suddenly going to draw up a due diligence policy. And I had a couple of UN staff members come down to see me and say, "You're a troublemaker, now look what we've got to do, so give us the answers, what should we be doing?" But at the same time, or very soon after, I went to listen to the then legal counsel give a major speech. And she said, "One of the proudest moments of my life was taking the initiative in ensuring legal accountability, or not accountability, but due diligence on the part of our peacekeepers." It was a complete misrepresentation. But because there was no documentation, OLA had never had to come out, issue a statement, make a formal policy declaration. It was very easy to just reshape the record. Finally, and I don't have time for this, but maybe in Q&A, there are, of course, the legal ingredients that were important in the Haiti case, which have a continuing, much broader significance. The question of an apology. A lot of work went into the Secretary General's so-called apology. And again, I was involved behind the scenes in different ways, which I won't go into because I had promised not to. But we have never satisfactorily resolved that issue. One of the things that I said to the UN Secretary General in private is that one of the few things for which a certain former Australian Prime Minister would ever be remembered was the fact that he made a formal apology to the Aboriginal people for what, but that was done, as you would imagine, over the advice of a zillion lawyers who said, "No, you can't do that, Prime Minister. It's going to lead to all sorts of terrible consequences." The reality is that if an organisation can never apologise, you're on a losing track. It's got to be able to apologise. Linked to that, of course, is legal responsibility. I think one of the things that most of us share, I know Kristen has written a lot about this and has a much more nuanced view, but I think the immunity of international organisations like the UN is extremely important. But there are so many ways in which legal responsibility could have been accepted in this context, and ways in which, as I said in pleas that I made to US lawyers, I went down to Washington on my own money. I visited the State Department, I visited the National Security Council, where I got absolutely no response, nothing, no explanation of the US position. And the position that I was putting was that, frankly, you guys are mad. This is a really easy opportunity to set up a mechanism which will settle these claims on a basis, a financial basis, which is viable, and in a way that rescues the credibility of the UN, but doesn't cause any problems with the issues that I think you have real concern about. No interest whatsoever. So we remain in this terrible situation where the UN is sort of trying to get into a shrinking space of legal responsibility, which again I think is a loser, is a losing proposition, and it's just going to become less and less sustainable. Finally, two related issues. You've got funds. There was once an insurance policy in the UN context, so that if major claims were received and the UN hadn't been able to set aside money, which is understandable, there would be insurance available. There has to be some sort of fund established, and it cannot be voluntary. There's no surprise at all that the voluntary fund established for both Haiti and Kosovo have received nothing, and they should receive nothing. Why the hell should governments be making voluntary contributions when no responsibility has been accepted? It's not an obligation of the UN to pay anything because they never did anything wrong, which of course is not correct. They did a lot wrong. They are responsible, and money has to be paid. But you make it voluntary, and you get what you reap what you sow. And finally, there's the question of remedies, which I won't go into now. Hélène Chegruja and others will be talking about it this afternoon. I think we need to have a much more open discussion about remedies. I have some insights into the work that Hélène is doing now, and I'm deeply sympathetic to her skepticism about much of the rhetoric that surrounds the payment of reparations. And I think we do need to have a much more realistic approach. But of course, what cannot be accepted is the UN, what I believe can't be accepted, and this is my final word, is that you can't simply say there will be no individual reparations in cases like this. I agree, incredibly difficult to sort out who deserves reparations in Haiti and who doesn't. Very complex, raises a lot of difficult issues, but in every other context, we always insist that a part of the response for serious human rights violations is for some form of reparations to be made available to the victims. And if the UN is not able to, again, try to negotiate that, but in a much more transparent way, instead of producing all these reports saying, yeah, well, of course, the Secretary General decided that there should be these, so we have 2 tracks, and yes, ideally there will be. But we should note that there are 3,297 reasons why this is going to be extremely difficult to do, meaning there is a complete determination within the organization not to go down this road. And I think it's a very bad path to go down, but we need perhaps a more realistic discussion. I've talked over time, but I'll leave it at that. Thank you.
Okay, so our first panel today will deal with UN accountability and the concept of responsibility in international law. The bios of the speakers are in your folders, and so I'm not going to go into detail with regards to their background, but I would like to say that these are 3 of the most interesting, critical thinkers on this issue today, and I am really honored that they were willing to come and speak. Mona Khalil worked at the UN for over 20 years, and she recently joined Independent Diplomat. She's an expert on public international law, has been involved in the details of many of the cutting-edge legal issues that have come before the UN, has spoken to the press with regards to the Haiti case, amongst others. She'll be our first speaker. After that, we'll go to Frédéric Magrey, who's a professor at McGill University in Montreal. He wrote a fabulous early article on the Haiti cholera case in the Belgian Review of International Law that I think really started the conversation amongst academics with regards to some of the complexities and the nuances with regards to the legal regime that applies in this situation. And Christina Daugerdes is a professor at the University of Law at Michigan, and she wrote a fabulous article on the reputational aspects of the UN's response to the Haiti cholera case in the European Journal of International Law. So thank you very much for coming. I've asked the panelists to speak for about 10 minutes each, and then we'll open it up for Q&A. Okay, Mona.
Thank you, Kristen. Thank you for inviting us here today to you've brought together, I think, a rather impressive group of people, and I'm very honored to be among them. First and foremost, I want to pay tribute to Philip Alston, who I think, seizing upon the legacy moment of the Secretary General, one that was obsessed with his legacy from the day he entered office, and his legacy was going to be climate change, and then it was going to be women, and then it was going to be a number of other things, and ultimately it was fear of the Haiti legacy that motivated the switch in position. Woefully late, woefully inadequate, as I think we will all be discussing today. But it's important first in this context to remember that Haiti cholera is not the only failure. There are other failures of the UN and of the UN system, and while we were focusing today on Haiti, I think we do need to highlight that there's failures in a case involving Kosovo. There are UN system failures with regard to WHO and drug-resistant malaria. There are failures from the World Bank's policy on user fees that I myself was not necessarily aware of until recently, thanks to Harvard Law School for convening many of the people in this room to address international accountability, or I should say accountability of international organizations in health-related crises. And while immunity is a fact, impunity is certainly something that we all want to avoid, and I believe the existing legal instruments stand for that principle. I think what we're seeing now is exception, not rule. I think it's actually a betrayal of the long-standing policy and practice, as well as the fundamental principles of our organizations of the UN system. And what we need is not a change in the framework, but rather an adherence and an enforcement of the system. So turning to Haiti, I think the failures are many and diverse and universal. There are several kinds of accountability. The first is performance accountability, I'd like to term it, then moral, and then legal. And in some cases, I don't think relevant here, there's criminal accountability. But I don't think that necessarily arises. I don't think anybody intentionally committed any crimes here. There may be some gross negligence on the part of some, including in the organization or amongst the member states. But if we can achieve legal accountability, I think most of us would be satisfied. So let's look at them one at a time and see where the failures are. Performance accountability is ensuring that in the conduct of your work, you behave professionally and responsibly and in fulfillment of the mandate. The mandate was fundamentally about protecting the people of Haiti. So there's a fundamental failure right there on a purely practical level. Were the measures taken consistent with reasonable standards of care? Whether it's the organization, whether it's the government, whether it's the troop and police contributing countries. We have yet to have answers to those questions, and I'm not prejudging what the answer will be, but why haven't we asked those questions? Where are the answers if those questions have been asked? Where is the transparency on the practical, logistical, and necessary due diligence and due course of things with regard to what the mission did and didn't do in setting itself up in the country? Then, of course, there's the all-important moral accountability. We promise to help. We're fundamentally bound to do no harm. Have we failed both moral promises to the people of Haiti and to these other peoples that I have mentioned? That question was partially answered with a overdue and insufficient apology. The fact that it was made in the language of the people of Haiti was meant to appease that sense of delay and that sense of delinquency. But it never addressed the fundamental issue. The apology was for failing to do more in the aftermath of the crisis. It was not an apology relating to the crisis or to the causes of the crisis. The legal accountability is also woefully inadequate. What we have is an immune organization with functionally immune officials and a few diplomatically immune senior officials. And while the organizational immunity may be absolute, there's an equally absolute obligation to provide appropriate modes of settlement when that immunity applies, whether it's the organization's immunity or the official's immunity. So there's no need to undo the immunity in order to reach responsibility and accountability. All that is required is that everybody fulfills all of their obligations in order to enjoy all of their rights. And even without the quid pro quo argument that many have put forward, and I'm not ready to reject it, but I'm certainly not ready to endorse it, because again, I don't think it's necessary. Ample precedent exists in the history of the organization where without prejudice to the immunity, the accountability was upheld, the responsibility was owned and acted upon, and the right thing was done and justice was served. And but for the failures that I'm about to identify, we would have had the same result here. The failures are across the globe. The Secretariat failed, and I would urge Mr. Alston to look at the time frame. The letter of the plaintiffs arrived at the end of 2011. The answer they received was more than a year later. If the UN's intention was to be dismissive about its obligations, the answer would have been much quicker. The fact that so much time elapsed reveals an internal struggle that I think has yet to be fully disclosed and would certainly not be disclosed here due to my own confidentiality obligations. The role of the legal advisor, who is the master of the legal opinion? Is it the law? Is it the Charter? Is it the Secretary General? Is it certain member states? Those are fundamental questions at play here as to why that failure occurred. Ultimately, the buck stops with the Secretary General, and those who feel that the UN is anything but one voice, ultimately the voice of the Secretary General represents the position of the organization. Where the UN stands is where the Secretary General stands. The member states failed miserably as well. First and foremost, the government of Haiti. We have the Belgian precedent where, against great odds, against great pressure from the Russians, the former Secretary General stood up to that pressure and did the right thing in a situation which was far more easy to get out of. It was military operations that caused harm to Belgian nationals and other nationals in the DRC. They bent over backwards to give compensation to the Belgians and those other governments. Why is that? Because the victim was white? Or because the government of that victim fought for its citizens in a way that the Haitian government has not fought for its own? Or is it that we had a more principled leadership in the organization at the time? I think there's elements of all three at play in the result that we have in Haiti and elsewhere. The other failure is the member states, the Security Council and the General Assembly. They were not unaware of what was happening. Former President Clinton, within days of the outbreak, attributed publicly the cholera to the Nepalese peacekeepers. The U.S. ambassador publicly called for accountability, and yet quietly behind closed doors, and this has been made public, so I'm not revealing anything, insisted that not a penny from the regular budget be spent on this atrocity. The other member states were well aware. Nobody demanded that the UN live up to its principles. Nobody asked for a follow-up report on what the UN was doing. Acquiescence in the face of such large-scale human death and disaster is also a contribution to the situation. So ultimately, it was neither performance, moral, or legal accountability that prevailed, but a certain form of public accountability. And that the reminder that the Charter is written in the name of we the peoples, the people of Haiti and the people of the world. And it was ultimately the people who held the organization accountable by insisting on asking the right questions. And it was that wave, ridden by the academics and ultimately by the Human Rights Special Rapporteurs a few years later, that ultimately prevailed in getting the organization to look in the mirror. A very self-serving mirror thus far, and one that actually adds insult to injury, in my opinion, because when it comes to financial accountability, that is woefully absent as well. What is being offered is charity to victims, not compensation to rightful claimants, with a legitimate and a relevant and a actionable, and I would say receivable, claim of action. Thank you.
Thank you very much. So I'll try to complement actually some of the things that you said. I'm going to be interested mostly in this presentation on the responsibility of a troop contributing state and the host state. And nothing that I say should be construed as minimizing the UN's own responsibility. And I've sort of been on the record attributing many of the things that went wrong in Haiti to the United Nations. Nonetheless, I think we've put ourselves in a situation as international lawyers, maybe because of the focus on control, on effective control, where we tend to see responsibility as fairly exclusive. Only one actor at any one time can be responsible for some of the harm that has occurred. It's either one or the other. So the troop contributing state in particular gets completely subsumed under UN responsibility for well-known reasons that have to do with upholding the notion that the UN does indeed have a separate legal personality. But I think in the process, we may be missing some of the nuance, and certainly I think there's more to be said in the case of Haiti, as Mona has already done, and Philip as well, on the role, particularly of the host state, but also of Nepal. And I think thinking about the role of states also provides an interesting link between the concepts of internal and external accountability. Now, I'm well aware that it may seem, in that particular case, quite unfair to focus on Nepal and Haiti, among the most destitute and poor states in the world. But in other cases, going after the troop contributing state in particular was the obvious move. I'm thinking of the cases, the Barami case before the European Court of Human Rights, or obviously the attempts to sue the Dutch government before Dutch court. So I think this is, in part strategic and dependent on the circumstances, but we shouldn't forget that in other contexts, going after the states has been a very plausible move. I think what underlies my reasoning on these things is the cholera epidemic, aside from the issue of responsibility, was the outcome of all kinds of causal factors. There's a whole sort of chain of causality, and I think rather than focusing on just one actor, I think it might be interesting to think in terms of how certain kind of complex governance constellations or networks end up making some of these events possible. I think there's also a slight political dimension to all of this. It's hinted at, the problem of racism, etc. I completely understand the urge to make the UN accountable and make, reforming our institutions of global governance. At the same time, I find that sometimes there's a tendency to sort of gloss over the potential responsibility of the host state as if its sovereignty didn't matter, right? So in some ways, in pushing for a degree of, for example, Haitian accountability, I think one is taking that sort of sovereignty seriously and saying, as civil society actors in Haiti have been, there's an issue there that deserves scrutiny. All right, so let me first look. Obviously, this is very tentative, and I won't discuss the facts in any detail. I'm just trying to suggest ways in which we could conceptualize this, the understanding being that, this has happened before, will continue to happen, so the challenge is to kind of extrapolate a little beyond the Haiti debacle to understand what's at stake. So briefly on Nepal first, and the responsibility of a troop contributing state more generally. Obviously, there's the UN was in charge of the MINUSTA and had effective control, and the Memorandum of Understanding makes it quite clear that the UN will be liable for claims. And so we find this was very apparent in the Barami case before the European Court of Human Rights, where states are all of a sudden extremely keen on this notion of international legal personality of the UN, and that, of course, everything was entirely under the control of the UN. And so, in a sense, our commitment to this internationalist idea that the UN really does have a distinct personality and ought to take the blame has put us in a bit of a dead end in terms of securing accountability for victims, because the UN then sort of course, in the European context or before the Dutch courts, claimed that it had immunity. So there are, of course, exceptions to this single focus on the UN as sort of having effective control. One of them is, they're quite limited, one of them is situations where states have sort of creepingly started reasserting control over their own troops, and that's the case of kind of Srebrenica and the sort of dying days in 1995, where the sort of Hague was sending instructions to its troops that suggested that they had sort of reasserted effective control. And what's quite interesting is these sort of transitional situations where really, and the Dutch courts hinted this, at some point it's not clear whether the Dutch bat was under Dutch or UN control. It could have gone both ways. They probably have taken orders from both actors. So that's one area where the state, the troop contributing state, might be liable. Another is, but I won't get into this, if the acts were committed ultra-virus. I don't think that particularly applies to whatever the Nepalese contingent was doing in Haiti. But I think there is one issue that maybe deserves a bit more exploration, where there's a number of questions that are unanswered. And that relates to the question of responsibilities for pre-deployment screening. So pre-deployment, imagine the Nepalese soldiers still in Nepal. Obviously, they're earmarked for a mission in Haiti, but they're not quite there. There's kind of, I think there's a gray zone, right? They are sort of, there's a commitment to send these troops to Haiti, but they are very much, I think, in some ways under the effective control of the Nepalese government. So this is, I think, this pre-deployment situation is fairly ambiguous, and the standard operating sort of procedure does seem to kind of significantly share the burden for medical screening. I note that the medical support manual for United Nations peacekeeping operations makes the health screening and immunization of peacekeepers prior to deployment a responsibility of a troop contributing country. And that doesn't extinguish the UN's own responsibilities on the grounds. That's kind of then passed over to the chief medical officer in the peacekeeping operation. But there's certainly a sense that the troop contributing state ought to be in a position to certify that the soldiers, the peacekeepers, have been immunized and won't pose a risk in the country they're being sent to. And certainly a policy interest in making sure that responsibility is taken seriously. I note also that in a separate issue of vetting peacekeepers before they go on missions for either sexual abuse or human rights violations, the pressure is very much on the troop contributing state to make sure they don't send sort of bad apples, so to speak. Now that might be a slightly different situation because so much of a disciplinary power even subsequently rests in the troop contributing state, so maybe they have sort of special powers there. But I think obviously this is at the very least a shared burden. Now, behind all this, I think there's of course a debate on whether responsibility can be joint or whether only one actor can be responsible. Possibility of joint responsibility to that in a number of contexts, including by the International Law Commission, the Dutch court in the Srebrenica case. But I think that leaving aside the question of whether, let's say, both the UN and the troop contributing state could be jointly or separately liable, there remains the fact that this is dealt with also at the internal level. In a sense, the lex specialis is that the memorandum of understanding anticipates that whilst the UN may take the blame, if only to uphold the idea that it is the actor in charge, it reserves the rights in certain cases to turn against the troop contributing state to claim back some of the money that it spent as a result of reparations. So the Article 9 of the Memorandum of Understanding says that the principle is that the UN will be responsible for dealing with any claims. However, if a loss, damage, death, or injury arose from gross negligence or willful misconduct of the personnel provided by the government will be liable for such claims. So obviously, then one has to ascertain whether the gross negligence is such that the troop contributing state is sort of exclusively responsible, or whether it's the blame is shared. But I think it's interesting to keep in background that beyond UN responsibility, there's still an a question of allocation of responsibility within the kind of UN legal framework. Now I turn to Haiti and the host state more generally, obviously a very complex issue. I note that Haiti is not Kosovo or East Timor, obviously a very weak and fragile state at the time, but very much a sovereign state. There's a few angles from which one can look at this. I'll mention three briefly. One is, I think there's a question of causality. The cholera epidemic is a combination of factors. It's not just the introduction, but also the scope and the breadth of the epidemic, and how quickly it spread as a result of an extremely notoriously poor sanitary infrastructure, etc. So the UN doesn't arrive in the void. There may be a question of contributory negligence. I note that the ILC's draft articles on responsibility of international organizations indicate that in the determination of reparation, account shall be taken of the contribution to the injury by willful or negligent action or omission of the injured state. And so that is relevant. It reminds me a bit of the UN's response in the Mitrovica case, where the UN was prompt to point out when it was alleged that persons had been poisoned in an IDP camp that it was in charge of, that the Mitrovica region has a long history of major industrial pollution, including lead contamination from the mine, etc. So the idea that the UN steps into an environment which is already significantly causal. The second ground for host state responsibility, I think, is the existence of an ongoing duty to monitor the acts of a peacekeeping operation on one's territory. And I think here, especially if we're thinking in terms of human rights, there's a well-known obligation by states to not only respect but also protect persons from human rights violations at the hands of third parties. That's often understood to be private third parties. No reason to think that it wouldn't apply to an international organization. And so that, simply because you're inviting a peace operation on your territory, doesn't relieve you of that obligation to sort of reasonably monitor what it does. And so there one would have to look at the reaction of the host state, the extent to which it took this as seriously as one should from a human rights point of view, the fact that a major epidemic had broken out. I note in that respect that the sanitary issues are explicitly presented in the Status of Force Agreement as a co-management sort of responsibility between the host state and the UN. That suggests that Haiti had not, abdicated all responsibilities in that respect. But maybe, and I'll finish with this, the third ground to think of the host state responsibility, and perhaps the most interesting one, because it's the one that has motivated a number of civil society actors in Haiti to react, is and has been mentioned already, is the failure by the host state to follow up a matter such as this, including aggressively and dynamically exploring all the legal avenues. And so here there's a question, an old question, of whether a state can exercise diplomatic protection on behalf of their citizens against an international organization. I don't think there's any problem with that fundamentally, especially in a case where we have a pretty obvious remedy. And that obvious remedy would have been for Haiti to call for the creation of a standing claims commission. The standing claims commission would have several advantages. I think first it would have maybe avoided a sort of early dismissal through the kind of local remedies mechanism, by providing victims with the extra support and credibility of their state in what is, a standing claims commission in which the UN and Haiti are sort of co-partners and equally represented, and it would have avoided having to take that detour through U.S. courts with a predictable outcome that UN immunity was upheld. So why Haiti did not avail itself of that possibility, I think, is an interesting question. I note that, of course, apart from a well-known case of Belgium and other European states in the Congo, standing claims commissions are sort of famously never used. I think there are a number of reasons. One of them is that host states are beneficiaries of peacekeeping operations, and sort of political dynamics are quite complex. They are sort of partial to these operations, and maybe in some cases unlikely to challenge them. But I think more worryingly, from a human rights point of view, it may just be that the victims within Haiti were simply not significant enough politically to get the Haitian state to take their defense by asking for the setting up of a standing claims commission. Now, what's interesting is that this apparently infuriated a number of Haitian lawyers who launched a case, and I have to admit, I've contacted them on Facebook, but haven't had a response yet. Information is a bit sparse, but there was a sommation to the government within a month, this was in 2013, to avail itself of this possibility to call for the creation of a standing claims commission. So this is very interesting. Nothing came out of it. It's very interesting that the sort of government, there's a Haitian political element there that I'm not entirely familiar with, but the Haitian government is very explicitly criticized and attacked for not taking seriously the rights of a part of its population. There are a few interesting things there. One is the connection between administrative and constitutional law and international law, that you're using domestic legal mechanisms to get your state to exercise an international power. That's another way of looking at the sort of internal, external. And the other thing is the idea that sometimes your human rights might stand, a much better chance of being respected in the case of Haiti cholera victims if your state does something as old-fashioned as kind of exercising its sovereignty and availing itself of its prerogative under international law. And I think we're sort of rediscovering the extent to which diplomatic protection, even in a world where sort of human rights are supposedly guaranteed universally, could be a significant piece of a puzzle of pressing accountability claims. Thank you.
My name is Larissa van der Herik. I'm professor of law at Leiden University, and I will chair now the next panel, which is titled Exploring Avenues for Accountability, Models for Dispute Resolutions Within International Organizations. So we will very much, I think, continue the conversation that we were having already with perhaps even more concrete focus on mechanisms of dispute resolutions, but perhaps also mechanisms of fact-finding. So if a situation arises, then what mechanisms do we have to decide on the facts, on what happened, and who can trigger any kinds of mechanisms for dispute resolutions, so the access to justice question. Perhaps we can also explore together what we can learn from other international organizations in terms of models. And I think also what we will do is perhaps we will broaden the conversation a little bit beyond Haiti. We will also look at situations not only of a private nature, private claims, but also situations where there's very clear criminal behavior. So what are the responses that we have or that we should have to criminal behavior, in particular, for instance, of peacekeepers and UN staff when there are allegations of sexual violence and abuse. So we have two speakers in our panel with very rich CVs. They have been everywhere in a way, to domestic level. Kim has been UNODC, participated in several negotiations for conventions, judge at the ICTY, now at the ICC, Canadian candidate for the upcoming ICC judicial elections. But perhaps for our conversation today, mostly she was the ombudsperson for the Al-Qaeda sanctions and against the odds, in a way, I think she made this office as effective as it could be. So she will hopefully also draw on that experience. And Larry Johnson, equally rich CV, now based at Columbia Law School, but formerly Assistant Secretary General for Legal Affairs. Like him, he traveled the world, former legal advisor at the International Atomic Energy Agency in Vienna. He was also at The Hague at some point in time at the ICTY. So I think very rich experience to continue the conversation as said. So the idea of the panel is to have an open conversation, a round table. I think the room invites that. So we will have some opening reflections, but I think then we can continue a Q&A, but also in terms of you offering more input, in particular also on this question of different models and what can we learn from other international organizations. So really to broaden also the conversation in different respects. So the order that I propose that we will have Kim first, and then we'll have hear from Larry, and then we'll turn to you in a way.
Well, thanks very much, Larissa, and it is a pleasure to be here this afternoon. When I was the ombudsperson for the Al-Qaeda Sanctions Committee, and you can ask the committee members, I was known to be a bit rebellious, so I'm going to be a little bit rebellious by taking us a little bit into the other field as Larissa forecasted, because I think when you have a workshop discussing the UN and accountability and you ask the question, what do we want to see accountability look like for the UN? I think you have to take into account, and I'll just do this briefly, the full scope of areas for accountability. And peacekeeping missions have created situations, as we've been discussing, of extreme health crisis, of situations of tort, but they've also created situations of allegations of serious crime in breach of trust of the peacekeeping forces. So I think we also have to include in the conversation what kind of accountability models do we want to see in that context. And I also think there's an interrelationship as to what's lacking, both in terms of how the UN responds in these situations, whether it be tort, whether it be the kinds of crisis that we've had, or whether it be the criminal situation. And we do have, in the criminal context, we've had these series of situations of very serious allegations of sexual abuse, sexual exploitation, and there are mechanisms which exist to respond to those situations, but we see a complete lack of effective implementation, such that there has essentially been very limited, if any, criminal accountability for tremendously serious crime, both in respect, and this is important, of allegations against the peacekeepers, but also a disproportionate number of allegations related to UN staff members, not part of the peacekeeping mission per se, but allegations of their inclusion in that activity. And I think there are various models that we could look at to try and address that particular problem. I'm not going to dwell on what I would call perhaps the very elusive, might be a mild way of putting it, potential of the Security Council establishing a tribunal, a standalone tribunal that would investigate and prosecute these offenses. I think we all in this room know that today that's for the dream. There is some very interesting work going on by Code Blue Project on the idea of whether for the staff members, states could come together and share their jurisdiction in order to create some kind of a body to which these cases could be referred to when there is no action being taken by the state of nationality, for example, of the UN staff member, because of course the UN itself has no criminal jurisdiction. So I think that could be a whole seminar in itself. But what I wanted to focus on just briefly, and then I'm going to turn to my ombudsperson experience and how it's relevant here, is the idea of a hybrid scenario, a hybrid mechanism that could be utilized both in this criminal context, but also perhaps in situations where something generally goes wrong. And to explain that, I would emphasize that, again, we don't have a situation here that there isn't jurisdiction criminally to deal with these matters. When it comes to the peacekeepers, of course, the agreements always reflect that there is immunity from prosecution in the place where they are, but that the responsibility for prosecution and investigation and prosecution rests with the sending state. In the case of UN staff members, there isn't that obligation, there isn't that agreement, there is no potential for the UN itself to bring the criminal proceedings internally for obvious jurisdiction reasons, but there is the state of nationality of the UN staff member that could investigate and prosecute, provided they have a jurisdiction. And often, but what we have not seen is the exercise of that jurisdiction, the proper investigation and prosecution of these cases. And I think we've been often jump to a wrong assumption. There's always the assumption that that's because, particularly with respect to the peacekeepers, they're trying to shield them, that the country in question doesn't want to bring proceedings against their own peacekeepers. And I think we should really rethink that assumption, because the bottom line is that extraterritorial prosecutions, and that's what we'd be talking about, are very difficult. And I say that because I practiced in the extradition field for 10 years, and I can tell you it's exactly the same problem with those states who will not extradite their nationals. Because the response in those situations for very serious crimes, murder, sexual assaults, there's a responsibility on the state of nationality to take those prosecutions domestically. And the number of cases I can probably count on one hand where states actually did that. And it's not because they were trying to shield anyone. It's because the problem is a lack sometimes of legal basis, not so much in the extradition context, but here in the peacekeeping and UN staff context it is. It's capacity. It's priority. If you have crimes being committed right in front of you on your territory, what's going to get attention first? And it's evidence, gathering the evidence to do the cases. So in this context, maybe the model we should be looking at that could also be very useful when something happens non-criminal is some kind of an independent mechanism that is present within the UN system, and I mean really independent, not part of DPKO, not part of DPA, not part of the mission, but an independent standalone body that sends in investigators immediately when we have situations that need to be investigated. And bodies that could then prepare dossiers, perhaps to transfer to the domestic state for consideration of prosecution, perhaps even sending prosecution assistance, or perhaps to transfer that independent investigative dossier back to the UN. But it would be immediate, it would be independent, and it would be a reaction that is there on a permanent basis. So I would highlight that as one of the models that I think that should be on the table for consideration in terms of how we address what may be at the root of the problem in a lot of these situations, those issues of capacity, priority, and evidence gathering. And the other, it's not that far away from the thinking that's gone into the creation of the IIIM for Syria, which is that you bring together the information in the hope then that you can bring it before a forum. So I leave that concept on the table, and then I want to shift to talk a bit about why I think, Kristen, because I don't have certainly an ounce of the background that my dear friend Larry does in terms of the broader topics that we've been discussing here today about the UN's response in terms of claims and dispute resolution. But what I do have some experience with is having sat as a judge within a standalone independent mechanism within the UN system, but probably more interestingly as having implemented an independent mechanism in the midst of the most political part of the United Nations, the Department of Political Affairs, and more specifically the Security Council Affairs Division, which supports the Council. And what I wanted to try and do was highlight from that experience is some of the general challenges I think would be faced in terms of however you structure a response to claims or to crime. And I know there are provisions to talk about establishment of a claims body that could deal with these situations. For every body or for every mechanism, for every model we talk about to be effective, it's going to have to operate independently. So here from the Ombudsperson experience are some of the challenges. And I recount these not because I want to be pessimistic about what the potential is, but rather because I think it demonstrates that what we need to have an effective accountability mechanisms in the UN is patience, persistence, and preparedness. And the Ombudsperson mechanism, which I think has been quite successful, demonstrates that. So just for your context, the Al-Qaeda Sanctions Committee was set up to address, place sanctions on individuals said to be associated to Al-Qaeda. Those individuals have all their assets frozen, they cannot move across borders, and they have a weapons prohibition. And after the tragic events of 9/11, hundreds of people's names went onto that list, and basically they sat on that list for many years. There were no reasons provided to individuals for their listing in the initial stages, no notification, and most significantly, no recourse available to challenge the fact that they had been placed on the list. And from the initial days, there was huge reaction to this situation that's a fundamental lack of fairness. This is the action of the Security Council, subject to a charter which talks about the Council acting in accordance with human rights law, and they had a complete denial of any fair process provisions for these individuals. So there were reactions from civil society, there were reactions from states. The Secretary General, Kofi Annan, took a personal interest in this situation and set out principles that should be used by the Council. I highlight all of this because despite that push, it took 8 years for any kind of fair process mechanism to be established. Just to show you, when you're talking about independent mechanisms in the UN, political will is a very hard thing to achieve, and the politics of surrounding these situations, as we've been discussing, are very significant. But you cannot but be working continually on the pressure. So I think the first lesson is they kept the pressure on. States within the Security Council, elected, permanent, plus a group of like-minded states, kept the idea on the agenda. Eventually they were aided, and I'm sure in this context there are situations that will aid progress, by a court. The European Court of Justice in a landmark decision in 2008 struck down the implementing legislation of the European Union for the UN sanctions, and that got attention in New York City. And as a result, the Office of the Ombudsperson was created. And it's a very good process. I'm not going to deal with the details of it today. I think that to the credit of the drafters, they carved out a very good process which met most of the requirements of fair process. And the interesting thing is that they were ready with the model because of all of the preparatory work that had been done by by elected members, by the group of like-minded states, and by Kofi Annan. So very important when we're talking about this, what do we want to see? Let's answer that question now, because the moment may come when we have the right opportunity to implement. So that's the sort of preparedness emphasis. And then the second thing was, though, the one thing that was missing when I took up the job, I was the first ombudsperson in 2009, what was missing was there was a very good process, but when you got to the end of it, when I would produce a report to the committee, I was not allowed to make a recommendation, and if one member of the committee opposed the circumstances pointing towards delisting, then it was over. So it was not an independent review process. Now, that was problematic. But instead of panicking, I took the job, the risk, and instead of panicking, they continued to, and I emphasize that I think, again, in this context, they continue to bring pressure both within the Council, from outside the Council, and the group of like-minded states. And within myself, they told me I didn't have a recommendation power, but I could make observations. So, of course, my observation was my recommendation. It didn't make me popular, but there we are. And remarkably, that pressure worked in the end, because when the resolution was renewed, they created a remarkable change, which was they provided, first of all, that the ombudsperson could make those recommendations, and secondly, if the ombudsperson recommends delisting and there's no consensus in support of it in the committee, 60 days later the person or entity comes off the list unless by consensus, the committee overturns the ombudsperson or it goes to the council for a vote. That has never happened, neither to me nor to my successor, meaning we have, in practice, took a lot of time and pressure, established what is in practice an independent review mechanism. And so I think there the word persistence becomes very important. Another important factor when you talk about models and mechanisms, costs. And that is a big, big factor. And one of the reasons I think the ombudsperson mechanism was successful is that when I was asked, after it looked like it was going to work, I was asked about resources, and I like to think my request was an extremely modest one. For the first 2.5 years, I did everything pretty well myself. I had a half-time secretary, but I asked for one secretary, assistant, and one legal officer, and that's still how the office is composed today. I did almost 60 cases. I think Catherine did about 10 with those modest resources, and that, I think, was also a key factor to its success. The last point before I turn over to Larry, who's going to take us back on stream a little bit, though, beware the bureaucracy. And Philip spoke earlier, you hit the nail on the head. I was prepared for the challenges of the Security Council culture. I was prepared for the challenges of the U.S. Treasury's culture. I was not prepared for the culture of the bureaucracy, which became a huge challenge. And I can sum it up. It's in Larissa's book, which is going to be launched later today. I've written a chapter on this where I rant. It was a toned-down rant. But we are 8 years into the Ombudsperson resolution implementation. The resolution called for the creation of an office of the Ombudsperson within the UN structure, and 8 years later it does not exist. The Secretariat has never implemented the resolution. It also, by its provisions, called for the establishment of contractual provisions reflective of the independent role of the Ombudsperson, and to this day the Ombudsperson is employed through the worst consultancy contract in the history of the United Nations, which has absolutely no protections for independence. Now, they've put in place some formal agreements, but we sit here with all the political will issues having been addressed, and the bureaucracy has blocked what I think is a very important component of this independent mechanism, of making it structurally perceived as independent. And I continue to point to this issue because we are at a point now where I think there's potential for, we've not had a good reaction necessarily from the courts, although I think it's been successful in knocking cases out of the courts. But we're seeing some glimmers of hope in the court giving some recognition to this mechanism, but it's got to be a better structure. So for whatever mechanisms we design in this broader context, I think that beware the bureaucracy is something else to bear in mind. I'm going to stop there and turn it over to my dear friend, Larry, who really has no interest in this topic, but he's been dragged here today.
So I thought you were going to accuse me of being a member of the bureaucracy. So I can understand that. Thank you very much for the invitation. And thank you for the previous speakers, because it's made my job a lot lighter, since the kind of things I was going to cover has already been covered to the greatest extent. But I appreciate your beginning, Kim, with the criminal aspect, and particularly in peacekeeping. So let me just comment a little bit on that and your ideas there. Certainly for non-lawyers, they confuse what the situation is with the military contingents of peacekeeping operations. And indeed, many of them seem to think that peacekeepers have some sort of diplomatic immunity, which is not the case at all. They're not covered by the 46th Convention on Privileges and Immunities of the UN. They're covered by the bilateral agreements the UN makes with the troop contributing country and with the host state, which vests exclusive jurisdiction over whatever the military contingents do in the sending state. They're out of jurisdiction except for the country that sends them. And of course that creates a problem when you have contingents that are being accused of having committed crimes or horrific things such as SEA. You know you're in trouble in the UN if you have an acronym. So it's sexual exploitation and abuse. But it's interesting, your idea. In some ways, it's in the peacekeeping field for the military contingents. And I didn't bring the material, so I don't have the exact facts, but you can find them probably on the peacekeeping website. There is now, once a peacekeeping contingent is accused of crimes like that, the sending state is supposed to, I think it's within 2 weeks, supposed to send investigators from their capital, from their military, their defense department, as it were, ministry, right away to investigate, because they'll be responsible for what their military have done, and they're responsible for disciplining them and prosecuting them and so on. So they come to the country where the act allegedly occurred, deal with witnesses, collect information, so on and so forth, and then half the time, most of the time for SEA, for sure, the offending unit is repatriated and sent back. They're supposed to then report back to the UN, the peacekeeping department, what has been done in their military systems of justice to discipline, to investigate, and to prosecute, and so on and so forth. Half the time they don't tell the UN what's going. So they keep having to hound countries, and it's probably right, most of them. But what unfortunately has been the case is the Secretariat has not yet been totally transparent about what countries have been doing. So I think last year they began to publicly announce what countries have been accused, their military has been accused of SEA. So that was publicly made known for the first time. And what I would hope they would make public also is which countries whose contingents have been accused have reported back what they've done, and which ones have said nothing, to try to name and shame. Because on the military side, unless your independent mechanism is going to deal with the military contingent, it's difficult to get a handle on the military as long as the militaries of the world that contribute voluntarily, there's no UN army, in spite of the idea in 1945, so are willing to turn disciplining of their military over to somebody else. And as of now, none of them do, including, and I know those that have been active in the SEA field and Third Committee and so on, go to the peacekeeping committee where the troop contributing countries are, and are just aghast at the lack of responsiveness on the part of even the best human rights countries, the Scandinavians, the Dutch, all Europe, the ones who are the foremost in giving lessons to everybody else in the Third Committee and in the Human Rights Council. No, don't touch our military, they're ours. We'll take care of them. So, and it's not necessarily, as Kim said, just because of shielding. I mean, take the example of Denmark. Now, Denmark probably has had no accusations against Danish contingents ever, so just it's purely hypothetical. But a country like Denmark, if their troops are accused of something, it's fine, they go back to Copenhagen, and if you start a process, what are you going to have? You're going to run into Kim's problems. Where's the evidence? Where's the victim? Down in Central African Republic. Is anything going to happen to that peacekeeper without proof, without evidence, without witnesses? So different ideas have been thrown out over the years. I think Prince Zayed, when he was ambassador of Jordan, did a report on this, and he included ideas such as the troop contributing countries would send their military investigators, like I was just talking about, to the site, or bring courts from Denmark, for example, to Central African Republic and take evidence and collect and take testimony, that kind of thing. And so they appeal to countries to change their, in fact, military system of justice to allow that, to investigate their own peacekeepers, and hardly anybody's done it. There's been massive silence on that point. Some of them, some commentators or some government people say it's against our own constitution. We can't. It's extraterritorial jurisdiction of a court. A Danish court that is sitting taking testimony in Central African Republic is difficult, or is against their rules of procedure or against our constitution. Anyway, that's one issue. But Kim's focus was on the issue of civilian peacekeepers, right?
Staff members.
Staff members, that's what I meant. Yeah, staff members. Now, for staff members, they're governed by, in general, by the Convention on Privileges and Immunities. And I want to thank Kristen and your colleagues for having put into the folders some great documents, including the 46 grand old convention, which is called the General Convention. And in there you see that staff members are immune, have functional immunity. Immune from legal process in respect of words spoken or written and all acts performed by them in their official capacity. So, if they're accused of a crime, unless larceny is included in their job description, there shouldn't be any question of any immunity to begin with. It's, you know, the job description doesn't cover crimes, hopefully. Anyway, so that's the norm, and that's what happens in New York and Geneva and Vienna and so on and so forth, but not in peacekeeping missions. Because normally when you're in a peacekeeping mission, the country is in dire straits. There may or may not be a functioning judicial system. So the normal rule, if you're in Central African Republic and a staff member is accused of committing a crime, the normal rule, you turn him over to Central African Republic authorities. Well, what if there aren't any authorities? Or what if the authorities, you don't have due process? The country's falling apart. The country has militias all over the place. So what you have, and it's not in your materials, but you have in your standard SOFA, Status of Forces Agreement with the host country, that if the government thinks that a staff member has committed a crime, the government goes to the SRSG, Special Representative Secretary General, whoever's the top secretariat person running the peacekeeping mission, to discuss the matter. And if it's agreed, then further action is taken. So, contrary to the General Convention, in peacekeeping missions, the SRSG can say, no, I'm sorry, I know this person is accused, but there isn't any court to send to give justice, to provide justice. And that's the gap which has been identified and which has been in the Sixth Committee for, say, 10 years, and the Swiss are leaders in that. In trying to do something, a convention has been proposed, sort of an extradite or prosecute convention, where you could get universal jurisdiction, so that if the staff member, if the Danish staff member is accused of committing a crime in Central African Republic, and then he goes to the south of France for his summer vacation, the French could pick him up under a convention. But that has gone nowhere, basically. They're still debating it. But, I mean, that's the gap that still needs to be fixed somehow or other. And as Kim said, the push in the Sixth Committee is to have the UN, or whomever has the dossier or information, probably not a real dossier, but anyway, information about the alleged crime, send it to the staff member's home country of nationality. Now, what are you going to do for the Americans or even the Canadians? If a Canadian staff member does something bad in Central African Republic, what happens if the UN just sends it to the Ministry of Foreign Affairs or the Justice Ministry in Ottawa? What are they going to do with it? You know, and so, I mean, this is supposedly a solution, but A, you don't know whether the crimes, the legislation, national law in each home state, as it were, will allow for prosecution of their national who commits an act abroad somewhere, what crimes are covered, what are not. And so lots of information has been pouring in, and lots of appeals have been made by the General Assembly that states make it a crime in their domestic legislation, that staff members of the UN in another place on mission will be held accountable in the courts of their home country. And some have followed through. Some say we already have it. Some say, nope, we'll never be able to do it, Constitution or whatever. And some have added, have changed their legislation. So that's where we are with the civilians. But there is a good idea. I think it's a great idea to look at an independent and fast mechanism to secure the evidence. And it fits with the IIIM, and in fact it parallels to some extent what's supposed to be happening with the contingents as well. You need to get there fast, get the evidence, get the testimony, and somehow make it admissible in court. You could have a domestic court somewhere to say, well, a bunch of foreigners and silly UN people were running around supposedly collecting evidence from a victim of rape, why should I admit this into court? Hasn't gone through our rules of procedure and evidence. So there are complications, but I think it's certainly worth looking at. So with that, let me come back to basics in terms of the 46th Convention. I mentioned the staff, and there is a provision at the beginning which gives the UN complete, pretty much ironclad immunity. The UN as an institution, the property and assets of the UN, wherever located, by whomsoever held, shall be immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. That's Section 3. The other section you should know for purposes of Haiti and in general is the settlement of disputes. We've already discussed Section 29, which talks about the obligation of the UN to make provision for appropriate modes of settlement for disputes arising out of disputes of a private law character. Sorry, there wasn't an earlier provision on staff members that talks about the Secretary General having the right and the obligation, the duty to waive immunity if asserting immunity would impede the course of justice. So that also comes into play for staff members. So that's the basis. Now, what does it mean, claims of a private law character? Because if you recall, and I think it's in the material, but certainly I think it was mentioned by the Special Rapporteur, the UN has claimed in the Haitian case that these are not claims of a private law character. Why is that? Well, that's sort of the missing whatever legal opinion, as it were. But actually, the Secretary General's Haitian expert did reply to the 4 special rapporteurs. I'm not sure it's public or not. Where basically he says that claims of a private law character could not include questions of policy. And their position was that the Haitian claims raised broad issues of policy regarding the functions of the United Nations and of the Security Council. And they are not receivable because they're not of a private law character, but implicate actions taken by the Security Council. Well, okay, we can all have our opinion on what that means, but what do you do when you try to find out what that means? You try to find the legislative history of 46. The problem in 46, which was out of the 6th committee, and I think it was also the PrepCom even before, that drafted this 46th convention, because it was one of the first resolutions adopted by the GA. There's very little and nothing on that Section 29. But thanks to a Dutch lawyer named Thomas Henket, who's now legal advisor in the registry of the ICC, who did his PhD on immunities, he looked the following year. The next year after 46, 1947, you have the Convention on Privileges and Immunities of the Specialized Agencies. And they use exactly the same language. So the same draftspersons, 1 year later, picked up the same language, but in 47, there's legislative history. And what he found, out of the subcommittee of the 6th, it says, with reference to the private law character, it was observed that this provision applied to contracts and other matters incidental to the performance by the agency of its main functions under its constitutional instrument, and not to the actual performance of its constitutional functions. So what are we talking in the Haitian case? Are we talking about what the peacekeepers are doing to keep the peace in Haiti? That would be its constitutional and its mandate. And you could see how the OLA in the past would have said that for Srebrenica and Rwanda, those disasters happened while the peacekeepers were performing their mandates, or not performing their mandate. But anyway, it was a question of mandates and what was their job as peacekeepers. It didn't have to do with Haiti and latrines. So, this continues, the 47 definition. It applied, for example, to matters such as hiring premises for offices or the purchase of supplies, I would add, and services. The provision relates to disputes of such a character that they might have come before municipal courts if the agency had felt able to waive its immunity. So this comes back to a little bit what was being discussed in terms of responsibility of other actors besides the UN. And to me, more than the issue of whether the Nepalese should have had some medical clearance or to what level they did have medical examination of their troops for cholera or other diseases. I mean, the UN does not build latrines. The peacekeeping bureaucrats probably are, maybe they did build these latrines. Probably they did. Maybe that's why they didn't work. I don't know. But somebody builds them. So what do you have? You have contractors. I checked with somebody in the peacekeeping department, ASG in peacekeeping, because I said, do the Nepalese bring their own latrines? As opposed to, and the French and the Germans have different latrines, in which case maybe you've got a problem here. He said, no, the UN DPKO contracts. So I don't know if it was a local contractor or where it was, but somebody was contracted. There's a contract out there, Bruce. The UN and somebody, go build these latrines. And I wonder who's responsible for maintaining those latrines, because in my view, the proximate cause was the latrines did not function properly. The waste seeped out into the river. That to me is the approximate cause. So if you did have a litigation, the UN could what was it called in the old days, implead, haul in the contractor and say, look, you violated these terms of the contract by building faulty latrines that led to, thousands of people dying and the UN being responsible for X amount of money. So, I mean, that's something else to bear in mind too. That's a comment on some of the earlier things mentioned. I want also thank you for having put in the 96 and the 97 reports of the Secretary General. And as I mentioned out to some other colleagues here, it's interesting, these reports, which deal with third-party liability for peacekeeping operations, were not in the 6th Committee. They didn't go to the lawyers at all. They went to the financial people, even though it's full of Section 29 and the Claims Commission and all of that other business. So it's interesting, and the resolution that is also in your packet on third-party liability is out of the 5th Committee. It's out of the Administrative and Budgetary Committee. So the lawyers basically have been, either they wanted to be kept out or they were kept out. I have a feeling they probably didn't want to get mixed up in it too much. But I do want to point out a paragraph 7 of the 96 report where it says, and read this and think about Haiti. In recognition of its international responsibility for the activities of its forces, the UN has, since the inception of peacekeeping operations, assumed its liability for damage caused by members of its forces in the performance of their duties. In conformity with Section 29 and the Model Status of Forces Agreement, it will settle by means of a standing claims commission claims resulting from damage caused by members of the force in the performance of their official duties, and which for reasons of immunity of the organization could not have been submitted to local courts. So that's the basic question of principle. So what happened here? In your SOFAs and in this regime that the 5th Committee has established for third-party liability, it's been mentioned, the Claims Commission. Why hasn't the Claims Commission ever been invoked? Never been invoked. And these two reports refer to that. And in fact, the Secretary General says he doesn't know why that they haven't been used. But just because they haven't been used doesn't mean they're not a bad idea, so we'll continue. So they continue to put in claims commissions in these SOFAs, and it fits into the liability of $50,000 cap per incident and so on and so forth. But why aren't they used? I use it in class by saying it's a perfect example where a wonderful legal construct is of no use whatever in the real world. Because we're not talking about an operation in Denmark, my favorite country today. We're talking about peacekeeping operations in least developed countries, countries that are plagued with civil war, outside interference, collapsing states. You go in as a lawyer Figure you go into your foreign minister or you go into your prime minister and say, let's use that claim commission. We've got a right under the SOFA. We can, Haiti tomorrow could have invoked it. Let's invoke it. Let's get our claims forward. Tell the public. Shout it from the rooftops. Bring your claims. And your foreign minister and your prime minister are going to say, well, you know what I've got? I've got a list of 80 things I need from the UN. I need UNDP. I need World Bank. I need UNICEF. I need WHO. I need roads. I need hospitals. I need this. I need that. And now you want me to go tell the UN, oh, by the way, I've got an $80 million lawsuit against you. It ain't going to happen. I think that's why. It's never been put in paper, but I think policymakers are going to say, why should I sue the UN when I want something from the UN? I need something from the UN to put our country back together again. Boom. So, in any event, I think I'm going to end in 2 minutes, but I wanted to come back with some of what Mona said also in terms of what should have been done or what might have been done. First of all, I think there is a problem in that this whole system we have in Section 29 and in the SOFA, it's all based on member states' sovereignty. Member states are in the lead. You can't get a claims commission unless the state asks for it, the state where the peacekeepers are. Individuals cannot ask for a claims commission. And you also have, of course, the 46th Convention is a treaty between states. Individuals can't invoke it. If you challenge the UN on their interpretation of claims of a private law character, who can challenge that? Only a member of the treaty. You can take them to the ICJ. You can take the UN to the ICJ and for an advisory opinion, and in Section 30 it says that advisory opinion will be binding. So where is everybody else in this? Why didn't anybody under the 46th Convention, the Scandinavians, or the human rights crowd? Where was Samantha Power? All of these other people saying the UN is playing around with this Section 29 in order to avoid their responsibility. Nobody said a thing. You're right in the middle of your state-centric system. I certainly don't have any solution to that. But that also, in terms of your question of what about functional immunity? Who are the big supporters, I would guess, of UN absolute immunity? The U.S. government. Why? Because who's going to pay? 22% the American taxpayer is going to pay. So if you're sitting in Congress, why should I expand the liability of the UN when 22%, if they're ever found guilty or if they're ever found liable for anything, is going to fall on the U.S. taxpayer? Boom. So I don't think any governments want to do away with the complete immunity of the UN as an institution because it's going to add to their bill, unfortunately. That's sort of the sad conclusion I've come to. And in terms of what could have happened, as Mona suggested, go to the Security Council and General Assembly, say, we've got a problem here. We're going to need to fix it. We're going to investigate it, and we'll get back to you. But alert them right away, we got a problem. Before doing that, I would also call in the Haitians and say, look, you've got the SOFA, you've got the Claims Commission, you could invoke if you wanted to, but in any event, you'd have to go hand in hand with them. And the reason why nobody else, by the way, stepped in was, I think, because the Haitians didn't. So even if you're the best human rights government in the world, one of the Scandinavians or Holland or Australia, New Zealand, whatever, they're going to say, well, it's their people. Why isn't their government complaining? They've got a mechanism and they're not doing. Why should the Dutch people or the Danish people plead for the Haitian citizens when their own government won't do it? So even besides the racist factor, which I think is a legitimate question, it's pure self-interest. I'll take care of my people, and that government takes care of its people. That's not for us to do. So what's interesting, I don't know how much of any of this was discussed in the Human Rights Council. I don't really think at all. So you need somebody to address these kinds of mass atrocities at the human rights level, it seems to me. And so I'll leave you all with that.
Thank you very much, both, for very rich presentations, very concrete suggestions, but also with an eye for political and practical realities and obstacles.
First up after me will be Helene, who will address the state of international law and the relevance of existing material under international law where the question of reparations has been raised. Next, I will turn to Beatrice to provide an overview of the issues relating to compensation from the perspective of the Haiti cholera victims, particularly in light of the UN's new approach. And finally, I will turn to Carla, who is with us, I hope, by Skype or on the teleconference, to pick up on where my and Beatrice's presentations left off, and who will draw on some of the new ideas that she has been developing in her two studies on Haiti cholera and on SEA. Next, I will open the floor to questions. I've been toiling in this area for many years, most recently in commenting on the UN's positions regarding Haiti cholera and on the UN's positions in SEA. At the outset, it is clear that since the United Nations establishment, the UN has been dealing as a good citizen on the world stage with claims for compensation for third parties injured as a result of UN activities. Throughout its many years, and only until recently, there has never been any serious question about the UN stepping to the plate and accepting its responsibility to compensate those injured as a result of wrongful conduct by the UN. This is true of contractual claims and claims for property damage to third parties over the very many years since the establishment of the UN. And there have been many, many claims of contract, tort, and property damage with which the UN has had to deal over the last 70 years. From the beginning, there was a focus on automobile accidents involving UN vehicles around the world wherever the UN was present. And the UN practice, virtually since its inception, has been to rely on insurance, worldwide insurance, to deal with these claims and let the insurer resolve the claims locally based on local practice and standards. Another early example included liability for accidents occurring in the United Nations headquarters in New York. Until 1986, the UN had insurance for torts that occurred in the UN headquarters in New York, and they were all resolved on the basis of local law and practice. However, because of the rising costs of such claims in the UN, driven by claims based on pain and suffering and moral damages, etc., the UN decided, through a unique basis provided in the United Nations Headquarters Agreement, to limit its liability to actual damages, excluding non-economic damages, and to self-insure against any torts that occur in the UN headquarters. So this is the first limitation. The UN is now limiting its compensation to damages that are actual economic damages, not permitting pain and suffering, not permitting moral damages. There are two other areas where the UN has established limits on compensation that it will pay, although both of these other areas relate not to third parties as such, but to military or police observers and members of UN commissions and committees and bodies. With respect to military or police observers, the limit is a maximum amount of $50,000 or twice the observer's basic annual salary, whichever is the greatest. With respect to UN commissions and committees, etc., the limit is a maximum amount of the UN pays the reasonable costs associated with treatment, medical treatment, burial costs, and survival benefits of $100,000 or $50,000, depending on who is making the claim, whether it's a close family relationship or a more distant family relationship. Until the late 1990s, the UN generally responded to claims for compensation for injury or damage caused to third parties by wrongful acts based upon local laws under well-established principles of international law. However, in response to increasing number of claims and size of claims in the peacekeeping area, the General Assembly determined to clarify and limit the liability of the UN in regard to such claims in peacekeeping missions. As a result, the GA adopted a new legal regime governing the UN's liability for third-party claims in peacekeeping missions only. There are no limitations on third-party claims in other contexts. The new regime imposes both temporal and financial limitations on the liability of the organization. The new financial limitations, as they apply, briefly are as follows. The new regime compensates types of injuries or loss, but they shall be limited to only economic losses. Again, no pain or suffering, no moral claims, no punitive damages. No compensation shall be payable for housemaker services and other damages that, in the sole opinion of the Secretary General, are impossible to verify or are not directly related to the injury or loss itself. Now, the amount of compensation payable for injury, illness, or death of any individual shall not exceed a maximum of $50,000, provided, however, and this is the important provision, provided, however, that within that limitation of $50,000, the actual amount is to be determined by reference to local compensation standards. So as one of our previous panelists pointed out, $50,000 in the United States is very small, but $50,000 well exceeds the standards of compensation in most of the countries within which peacekeeping missions are conducted, whether it's Haiti or whether it's Central African Republic or whatever it is. Now, the Secretary General has the discretion to exceed the $50,000 limit in particular case if the Secretary General finds that there are compelling reasons. This has never been exercised. I will now turn briefly to the issues of compensation as they relate to the United Nations and sexual exploitation and abuse. Frankly, there is no such regime governing compensation as to such victims of SEA. There is a regime covering assistance to victims of SEA. This assistance is provided in accordance with a resolution providing comprehensive strategy on assistance to victims of SEA by UN staff and related personnel being peacekeeping personnel, and others who are related to the peacekeeping mission. The assistance takes the form of medical care, legal services, support to deal with psychological and social effects of the experience, as well as material care such as food, clothing, and emergency and safe shelter. In addition, children born as a result of SEA are to receive assistance in regard to their individual needs. But such assistance is to be provided not as of a right to the victims claiming against wrongdoing by the UN, but as a matter of policy and only to the extent that the UN mission on the ground has the resources to provide such assistance. And what they mean by the UN mission on the ground, it's usually a combination of not only the peacekeeping mission, but other related humanitarian missions that may be operating in the same context as the peacekeeping mission, whether it's UNICEF, which is usually there, or UNDP, or any of the others. Indeed, the General Assembly resolution calling upon missions to provide this assistance explicitly states that the provision of such assistance, quote, is not intended as a means of compensation, end of quote, and is not being provided in response to any wrongdoing by the United Nations. Thus, the resolution makes clear that the policy of providing assistance, the strategy, as you will, shall in no way diminish or replace the individual responsibility for acts of SEA, which rests with the perpetrators of such abuses. The UN has established a trust fund for the victims of the SCA to support its strategy of assistance. And the Secretary General has recently called upon member states to support his proposal to tangibly improve medical, social, legal, and financial assistance to the victims. He added at the end, where appropriate. This gets into the issue. The Secretary General and the UN goes hand in hand to the General Assembly and is asking for voluntary contributions to this trust fund. The Secretary General has also indicated that he would explore the possible use of ex gratia payments to victims in exceptional cases and only where the member state mechanisms do not lead to an appropriate outcome. Ex gratia payments mean they're based not on any legal basis, but on a matter of policy and humanitarian regard. Those are the only regimes that establish any kind of limits or any kind of recourse to compensation as such. I will now turn to our other panelists and I would ask Elaine to share with us her views on the issues of standards of compensation from her broader perspective on international law and practice. Thank you.
Thank you. Indeed, I'm going to try to answer to the question raised by Kristen at the beginning of our discussion about what kind of model of reparations we could find in a more general perspective, and especially I'm going to adopt a human rights perspective and transitional justice mechanisms perspective. And in order to open the discussion, I will suggest, based on this international practice, that we could find three kind of models of reparation or three kind of philosophy of reparation. And you will see that the common features of these three kind models of philosophy of reparation is precisely the value-based approach and the victim-centric approach. And you will find the of dignity of the victim, non-discrimination, and principle of equality. Models the first is the idealistic model or the ideal model, the second the pragmatic model, and the third the realist model. And we have a little bit discussed about this model because it's based on the Human Rights Advisory Panel for the Kosovo. So what I call the idealistic model of reparation based on the current practice would be the model of reparation applied by the Inter-American Court of Human Rights when there's a violation of the Inter-American Convention adopted in 1969. And this is, to my mind, an ideal model in the sense that the court, when dealing with reparation issues, is guided by different principles, and especially two principles: the full reparation principle combined to the pro victima principle. And the consequence are the following. In general, in its case law, the Inter-American Court of Human Rights tries to find first, I do not have the time to give you judgments, etc., but I try to summarize. Tries to find first the most protective definition of beneficiaries. And it's very significant, for instance, when cases brought before the Inter-American Court involve groups of victims, hundreds of victims, etc., because the Inter-American Court will try to combine individual measures of reparation and collective measures of reparation. And of course, in the case we are interested in, it's very significant to have this kind of combination. Second, the most protective definition of injuries. Christina recalled that in general, under international law, you've got a kind of narrow definition of injuries, what can be granted for reparation, etc. And in the case law of the Inter-American Court, the definition of injuries, it's a very broad definition. I mean, the Inter-American Court tries to repair all the economic, non-economic consequences of a violation of the American Convention. And here, in its case law, the non-pecuniary measures are very significant. And the public apologies, we have discussed about this, the public apologies take a very significant place in the case law of the Inter-American Court. And it's very precise, it's very detailed, how the apologies should be made, in what kind of newspapers, in which TV program, etc. So it's very significant in the case law. Also, the content of reparation, and it's a kind of combination of compensation, money, but also symbolic measures like building of school or the construction of a museum, public, as I said, public apologies also. So the content of reparation is interpreted based on these pro victima and full reparation principles. And another significant aspect of its case law based on these two principles is that the Inter-American Court tries to find the most efficient way to protect the beneficiaries from the non-implementation measures or from the non-payment of compensation by the state. Of course, when I say that it's an ideal model of reparation or an idealistic model of reparation, I'm not talking about implementation, because you can guess that in general state do not respect or do not respect immediately the orders decided by the Inter-American Court. But it's idealistic in the sense that, as I said, the Inter-American Court is guided by these two core principles. And it's very ambitious, of course, in that sense. The second model of reparation is the model I called pragmatic, because it takes into account the pushbacks, the difficulties of implementation, the different problems that could be raised by the idealistic model of reparation I mentioned. And this approach of reparation is proposed by another UN Special Rapporteur, another NYU Special Rapporteur, Pablo de Greiff. In his report adopted and published in 2014, focusing on reparation, Pablo de Greiff is the Special Rapporteur on promotion of truth, justice, reparation, and guarantees of non-recurrence. And it's more pragmatic in the sense that the Special Rapporteur points out the fact that full reparation most of the time is not available, is not possible. And the content of reparation, of course, will depend on different factors, economic factors, social factors, political factors. But his proposals on reparation, even if it's more pragmatic, are closely linked to the Inter-American Court practice or the Inter-American Court philosophy, in that sense that the Special Rapporteur pleads in favor of a comprehensive, holistic, and global approach of reparations based on the principle of equality, the principle of dignity of the victims, and the principle of non-discrimination. And there's a very significant thing they point out in its report regarding money. He explained, and I think it's very significant to keep this element in mind, he explained that in the context of transitional justice, massive violation of human rights, post-conflict situations, etc., being responsible does not mean, and I quote, does not mean only distribute indemnities, but implies many other actions, reflection, etc. Repairing a wrongful act, repairing consequences of this wrongful act, it's not only paying for injuries. And we must keep this in mind when dealing with the Haitian case. And the economic dimension of reparation, of course, is very significant, but the discussion often cannot be reduced to the question of how much the violation of international law will cost for an international organization of how much it will cost for the states if we retain this idea of state responsibility. And so this model is pragmatic, but it's also very ambitious from a moral point of view and in the term of protection of victim. So perhaps it will not be followed by the UN, but it must be put on the table. The third model, I will be very brief because Christina discussed about the Human Rights Advisory Panel for the Kosovo. So the third model, the realistic model, is provided by this example of the Human Rights Advisory Panel established in 2006. It's more realistic, of course, because it's very interesting to read in the final report published in 2016 the political struggle, the political fight between the panel and the UN administration. And you know, as we said previously, it's not so different from what we are witnessing for the Haitian case. Just keeping, I think it's important to keep in mind that this advisory panel considered itself as a quasi-judicial organ, and it received more than 500 cases. So the media, etc., focused on the lead contamination case, but it was not the only case dealt with by the advisory panel. And in the decision, not the judgment, but decision adopted by the panel, there were many violations of human rights, as the right to life, prohibition of torture, ill treatment, racial, gender discrimination, violation of economic, social, and cultural rights of minority, deprivation of liberty, of property, access to justice, etc. And as a measure of reparation, the panel recommended, in general, public acknowledgement and public apologies, plus payment of adequate compensation, plus adoption of guarantee of non-repetition, for instance, protection of IDPs or different kind of measures toward UN bodies who work with IDPs and refugees. And in the final report, the advisory panel noted that as a follow-up response received by the UN mission, no public apologies were made, only a letter sent to each of the complainants, and no compensation paid, of course. And Christina mentioned this statement adopted from the Secretary General, adopted in May 2017, and it's the perfect, and that will be my final word, the statement made in May 2017 is the perfect counter-example of the philosophy of reparation promoted by the Inter-American Court, the UN Special Rapporteur, or the advisory panel, because it's in totally breach of the principle of equality and non-discrimination between victims, because if you read the statement, it's only focused on one case decided by the advisory panel, the lead contamination case, and there is, of course, no public apologies, and you will find this nice formulation of our shared duty to protect minorities. So it's not the responsibility of the UN, but it's our shared duty. So, of course, it's in violation of this principle of discrimination I mentioned earlier. But just as a final word, in the report adopted by the panel, the final section is dedicated to the future, and it's very interesting because it's a kind of roadmap. Of course, the members of the panel had in mind the Asian case, and it's a kind of roadmap of what could be done and what could not be done in the future if, as you asked the question, we want to improve the mechanism of accountability, or we want to improve the management of this kind of crisis. So the report is interesting for the Kosovo situation, also for the Haitian situation, but perhaps for the future for other kind of improvement of management of the UN.
Thank you very much, Elaine. We've gone from the UN to the general international law. Now we're going to go to Beatrice, who's going to talk about Haiti.
Great, thank you. So what I would like to do is bring the conversations that we've been having throughout today into focus from the experience of Haitian victims and their representatives, such as myself and the group that I work with, the Institute for Justice and Democracy in Haiti, as well as our Haitian partner, the Bureau des Avocats Internationaux, who have been trying to activate some of these procedures to try to access justice for victims of cholera. And shed light on what it looks like from that kind of outside perspective. And so, as you know, this is you can see kind of vaguely here in the background the base that we now know was the source of the cholera outbreak in Haiti. This is a photo that I took about a month after cholera broke out for the first time in Haiti's history in October of 2010. And you see in the foreground here also women who are using this river that flows from the tributary that runs alongside this base, where they're doing laundry even a month into the outbreak because of the lack of other alternatives, not because of a lack of knowledge that this water had been contaminated by cholera. And so although it took several months for genetic reports to come back to note that the strain of cholera in Haiti was a perfect match to the strain in Nepal, several months for the UN to appoint an independent panel of experts to investigate the source, in Haiti, it was really only a matter of days until we found out what the likely source of the epidemic was. This is a GIF from news footage that was taken by Al Jazeera about 6 days after cholera broke out, and shows Nepali soldiers who are desperately trying to clean up sewage that's actively leaking into the tributary that you just saw. And so cholera by now, actually this week marks the 7th year of the cholera epidemic in Haiti, and it continues to be the deadliest cholera epidemic in the world. About 10,000 people have died according to official records, and about 1 million people have been sickened by cholera. And it's difficult to overstate the devastation that cholera has had both at a household level in Haiti and on the country at large. So as a result of cholera, we've seen the death of breadwinners, we've seen children being orphaned, we've seen many families have to go into debt to pay for funeral expenses, to cover the time that they have been unable to work as a result of cholera. And because of those crushing debts, they're often debts that they continue to have to pay back to this day. And as a result of both the loss of income and these debts, that children are being pulled out of school. And so we're also seeing kind of generational poverty that's resulting directly from the cholera outbreak. And so as we've heard, the cholera case, I think there's a lot of agreement in this room that it fits very squarely within the UN's obligations to settle claims. Specifically, the Status of Forces Agreement between Haiti and the UN specifically says that personal injury, illness, or death that's attributable to MINUSTA, the peacekeeping force in Haiti, shall be settled by a standing claims commission. And so in accordance with these provisions that create this legal obligation, we, about a year after cholera broke out, filed claims on behalf of 5,000 victims that sought to activate both this procedure and sought to activate access compensation for victims as well as a public apology and investment in water and sanitation, going to these broader views of what remedies look like in these types of situations. And as we've also heard, this is the response that we received from the UN Office of Legal Affairs 15 months after we initially filed the claims. As a side note, in trying to interpret what this language meant, we actually did go through the UN Juridical Yearbooks dating back to 1967 and found only one decision that goes to anything related to these kinds of claims. And it was a very heavily redacted opinion, and so really the only takeaway from it was that the UN in that case had decided to provide compensation because it was determined to be in the interest of the organization. And so no details as to how they were dealing with the legal obligations at play, whether it triggered private law claims, none of that was actually a part of the published decision. And so in the face of this intransigence and our inability to access either the Claims Commission or even a meeting with the Office of Legal Affairs to try to understand why they were rejecting our claims, we have since then launched a massive public advocacy campaign that, as you've heard, has included litigation. This is going to be a problem if this won't work because this is a long slide. Let me actually just step up here for a second. And so have launched a massive advocacy campaign that has included litigation, reaching out to the UN Special Rapporteur system, US members of Congress. There has been significant advocacy that has also involved trying to get the Haitian to speak out on behalf of victims, as well as advocacy in the streets in Haiti, protests here in the United States, and just basically anything we could think of that would allow us to put adequate pressure on the UN to come around and offer some kind of remedies in this situation. And I show this chart partly to show that accountability within the UN system at the moment is in no way linear, that it's ugly in practice, and I think that's very much what we've seen, and in the end finally did result in a change in direction by the UN. So finally, after 6 years of advocacy, in August of 2016, there was a huge breakthrough, as Philip Alston mentioned, and in large part due to his advocacy as well, where the Secretary General finally issued a public apology and launched this $400 million plan that is bifurcated into two areas. One goes to cholera treatment and elimination, and the second is allocated for, quote, material assistance for those who have been most impacted by the cholera epidemic. And so what we've seen throughout the formulation of this plan is a very strong avoidance of using terminology around compensation, remedies, reparations. But nonetheless, I think we have felt very hopeful that the content of this plan in broad strokes has very much corresponded with what victims have been asking for over the years, and a lot of potential in this to, in substance, meet victims' right to an effective remedy. And this quote at the bottom here is included also to show that, again, there's never been an admission of legal liability, but this entire endeavor has been framed very carefully in the context of the UN's moral responsibilities and the collective responsibilities of the UN's members to act. So since this was launched now about a year ago, we've seen more and more of the contents of this get fleshed out. But from the very beginning, there was a contemplation of material assistance consisting either of an individual approach that would seek to remedy individual households, at least in those cases where families had lost breadwinners, had lost loved ones, combined with a community approach that would try to address those communities that have been most heavily affected, or some combination thereof. There was also a very strong commitment in the report to put victims at the center and a commitment to develop the details of what material assistance was going to look like in consultation with victims. Now this brings us to today, about a year after this plan was launched. Where we are at the moment is that voluntary contributions for the trust fund that's intended to fund this initiative has amounted to $4.6 million out of $400 million asked for. This graph here on the side shows how much member states have invested in the UN peacekeeping mission that's been active in Haiti. This is just the amount of money that's been invested since cholera broke out in 2010. It amounts to $4 billion, so 10 times the amount that the UN has asked for the cholera response. And then a minuscule portion of that that's been raised specifically for responding to cholera. And this in a country that, where cholera has become one of the biggest threats to development, to stability, in a country that has not had a war in our lifetimes. And so I think big questions to be asked about the political commitment to accountability, because as much as we're in a situation of financial constraint, I think this shows that it's not a question of absolute lack of resources, but rather where those resources are being put. Also to date, there has not yet been any engagement with victims in developing the substance of the material assistance plan. So the UN is now saying that there will not be nationwide consultations until there's some promise of funding from member states. And so we're sort of in this chicken and egg situation where we can't move forward on either front until there's progress on the fundraising. And finally, I think where this becomes particularly problematic is that at the same time, the UN is clearly moving away from its commitment to developing this package in consultation and is instead articulating a strong preference for community projects to be the sole way that this gets addressed. The UN just finished the first phase of a symbolic project in Haiti that's essentially setting the stage for piloting how the rest of the material assistance package will be rolled out. And the only way that victims were engaged was in a larger conversation about what local development priorities are in that area, without any attention to what they as victims of cholera would like to see, what type of remedies they need, and the ways in which they have been harmed. And so in contrast, here are just a few quotes. We have completed focus groups in about, in a number of communities in Haiti that's included about 2,000 victims of cholera to try to, in part, make up for the fact that the UN has not engaged directly with victims. And one of the perspectives that has come through very strongly in those conversations has been this articulation of harm at the household level and major questions around how does a community project help those who are the most marginalized, the most impacted by cholera, who may live a 4-hour donkey ride away from a community center? Are they going to be able to benefit from community projects? How does this actually help in that situation? And how does it help me when my wife died and she was the one who was the breadwinner of our family and we're really struggling economically? I also, this photo here, I just want to highlight because it says at the bottom in Creole that the United Nations agrees that it's responsible for cholera in Haiti. Now the Haitian state must make sure that compensation to victims comes through. And so it's not for a lack of effort within Haiti that the Haitian government has not been speaking out on this issue. And actually, on that note, I should also say that the Haitian president, in speaking to the General Assembly just this past September, stated a preference of the Haitian state for remedies to take the form of individual compensation. And yet that has not at all shifted the conversations that seem to be happening at the level of the Secretariat and the UN country team in terms of how this is envisioned. And so I would also, I think, pose the question back as to how confident we are that action by the concerned member states, at least at this point in time, really matters within a much broader political conversation that tends to be dominated by member states who have their own financial and political interests in perhaps not seeing individual compensation in these cases. So I just want to, as my almost final point, share some of the objections that we've heard in our conversation with member states, with the UN Secretariat, about why individual compensation is being abandoned at this moment. I think we've heard over and over again that there are technical challenges to identifying victims and big concerns about creating division in Haiti. There was a lot of speculation at various points about the role of racism in this issue. And I will note on this point in particular that the number of conversations I've had in which the counterpoint has been, well, you know Haiti, you know Haitians, and you know how prone it is to conflict. Haitians are the types of people who, will expose their children to cholera as a way to seek compensation. Haiti is so prone to conflict that you couldn't possibly introduce reparations in a certain for a certain number of people without it leading to broader conflict is something that has not been very good for my mental health. But I think is worth noting, because I do think that is certainly not the dominating factor here, but at the same time a force that complicates why there has not been justice in this instance. And I think that the answer to this question is ask Haitians, engage in actual consultations, engage in a feasibility study. And also, really what I think is happening here is a big concern about creating a new precedent. And I won't go into this in much detail, but I think, on this point, it's clear that compensating victims for cholera of cholera in Haiti is actually very consistent with the UN's well-established legal obligations. And so the only reason we should be concerned about precedent is if we're creating a new precedent that doesn't actually satisfy those legal obligations. And so on my final note, I would be a failure in my role as an advocate if I didn't take this opportunity to appeal to the people in this room to keep this conversation alive, because this is very much a live issue today. So this photo here at the bottom is actually a photo from this morning where victims of cholera in Mirebalais, where cholera started, in face of the UN not having taken any action since the public apology to translate that into action on the ground in Haiti, have organized their own commemoration, and that sign that may be hard to read says, "No justice, no credibility." And that's deeply, deeply relevant at this moment where the UN just last Sunday closed down their peacekeeping force in Haiti after 13 years and opened a new, smaller mission that's aptly branded MINU Just. And I love this photo here in the corner because you can actually, if you look carefully, see the white paint that has been painted over the sta part of MINUSTA and replaced with the word just. And I think as an international community, as experts who are concerned with this issue, we need to ask ourselves how it makes sense for the UN to be deploying another mission whose explicit mandate is to promote the rule of law and justice when the cholera issue remains unresolved. And is that where we want to be putting our resources? How can we move forward on this issue? Because I do think it's clear that this is an issue that very much brings together all the conversations we've been having, but in a manner that still has not reached a final answer yet. And so I think there's a lot of opportunity for us to continue to engage on that. Thank you.
Thank you very much.